inevitably, I think with 5 speakers, we've run a slight bit over schedule, so I'll try and condense my talk so that we're finished still in time for the break and for coffee and so on, conscious that I'm 55. So I'm here today. My name is Kate Egan, as you said. I'm a practicing barrister, practicing in the area of judicial review, data protection and public procurement law. So I'm here to give you a sort of a whistle-stop tour of public procurement law, which is an area that governs a lot of contracts in the state, in particular contracts with the state and contracts for utilities and of a particular value. So it's an area that's regulated mostly by European law, which we have implemented into Irish law in a number of regulations. And it's quite tightly regulated for the reason that these contracts are considered to have public importance, a public dimension and actually an international dimension as well, or at least a European dimension. So that's why there's such strict regulation of these contracts, of how these contractors are hired effectively, and of how the process is carried out in order to carry out public works. So that's why it's important. It's a kind of a niche area, and what I'm here to talk to you about is the way to review a process if you are an unsuccessful tender who's perhaps spent €1 million on trying to tender for a particular piece of work. How do you challenge a process which has been unfavourable to you, which you haven't got the result that you wanted, which you think has been irregular or unfair for some reason? So that's what I do with the judicial review process, and as I say, it's European law that we've imported into Ireland, and that's what I'm here to tell you about. Okay, so you have the list of the various regulations and things there. The way to challenge it, basically, there's a special judicial review process just for public procurement decisions. So the usual principles of judicial review apply, but there's a special order, it's called Order 84A in the rules of the Superior Courts, and they regulate how the procedure is for challenging these decisions. So it's like a normal judicial review application in some ways. In theory, you're supposed to go in to the High Court and look for leave, for permission to bring a challenge. It's a little bit different in procurement law in that everything runs quite quickly because of the importance of these decisions. Parties generally are cooperating, and I was interested to hear David's point regarding the ongoing relationship between parties. That's always a concern in procurement litigation, and it's something that people manage to sustain despite these challenges and despite going to the High Court, but it's a concern for both sides usually. So there's more cooperation in these cases than you would perhaps find in a normal judicial review application against the state or against another public body. So that's a peculiar feature of these cases. So the procedure is that somebody goes into the High Court, asks for permission to bring a challenge to a decision that's been made. And I'm sort of skipping through the slides here just to make sure that we get through everything. But what you do is you go into the High Court. Once they designate that you're allowed to bring a challenge, the proceedings are brought into being and everything moves quite quickly from then on. So that can be contrasted with a normal judicial review application in that sense as well, where it usually takes a year or 2 years to get a case before a High Court judge for hearing. Another feature of these cases is that there will sometimes be, as I said, cooperation between parties, and a feature of that is that you will often get disclosure, as they call it in procurement law, discovery in Irish law, before it's ordered by any court. So there's a level of cooperation in these cases that you don't ordinarily see in judicial review applications, and that means that the cases can be resolved quite quickly. You can preserve the relationship if possible at all, and generally you'll be looking for a speedy resolution given the nature of the contracts involved. Okay, so the kind of remedies that you'll be looking for, obviously when you launch a challenge to a particular decision, you're looking for the suspension of the procedure in the first instance. So you're trying to stop the tendering party from entering the contract with the successful party or parties. That's the first thing you want. So you want to press pause and stop that agreement from going ahead so that you can challenge the procedures under which the award was made. So that's the first thing. The regulations require a standstill period, as it's called. So there's a 14-day period within which a contract cannot be concluded to give unsuccessful parties a chance to challenge the award of the contract. So after that, you need to go within that period into the High Court and press pause, as I say, look for a suspension of the procedure. Once you get proceedings in being, the suspension kicks in automatically. So what becomes difficult after that is that the respondent will possibly apply to have that suspension discharged. And that used not to be possible. There was a case called OCS and Dublin Airport Authority. This appears to be malfunctioning at the right time. Yes, so just before you go into court, the most important thing, and I can't stress this enough, is to get timely advice. As soon as you get notification of an unsuccessful tender application, or if you're on the other side, as soon as you get a letter, a pre-action letter, which the applicant is required to send you, you need to seek immediate legal advice. As I said, these things move quite quickly, and everything from there on will be in front of the court, in front of the judge, so you need to think very carefully about what information you want to share, and on what grounds you want to make that challenge. So that's the crucial point with these cases, and the crucial takeaway, I suppose, if you will, is that everything moves quickly, so you really need to get advice as early as possible. So the applicant is required to send a letter setting out the grounds on which they intend to challenge. That's different to normal judicial review, which is usually ex parte or without notifying the other side. Also different is the fact that they're required to notify all interested parties, not just the proposed respondent. So everybody is at the table from the beginning. Again, also different to ordinary judicial review. The time limits are quite strict. I'm not going to dwell on them particularly, but that case, DECRA, is an example where it wasn't allowed to be extended. And importantly, the time runs from actual or constructive knowledge of the decision. So that means that even if you're informally notified, if you get a phone call from somebody saying, actually we've given that to somebody else and it was based on such and such a consideration which is not legitimate, you're actually supposed to move from that point on to try and get your leave and your proceedings in being. Okay, so ubrimus fidus is not the idea that you have to tell the court absolutely everything, even in material against you and so on. It's not as big a consideration in these applications as in most judicial review, because the other parties will be present. It's kind of usually on notice, even though it's not required to be. So that's not such a huge thing. And we've talked about the effect of securing leave and the suspension. What has happened is that in 2015 there was a case, OCS Solutions at Dublin Airport, which I've given you there the citation for, and in that case the respondent was applying to discharge the suspension, to basically say, we've done this procedure fairly, it's going to cost us a lot of money if we can't enter the contract and we can't go ahead with the works. So they asked the court to allow them to go ahead pending the decision. The court in that case, Judge Barrett, said he didn't have power to interfere, so once proceedings were in being, even in that case, they had been commenced outside of time, and there was no requirement for an undertaking for damages. But notwithstanding all of that, the court said they had no power to stop the suspension or to discharge the suspension, which obviously had draconian impact on the tenderer. The Supreme Court upheld that. So in 2015, the Oireachtas promulgated another regulation which says now that there is power in the court to discharge that, but it necessitates an application. So what that means is, if you launch your application to challenge the tender, the tendering committee can respond by asking the court to discharge the suspension, meaning that they can go ahead with the contract and get whatever works they need carried out. And the test that was recently litigated in the Alexon case, the last one, the middle case, BAM, is another case in the area, but it's an interim decision, so it's not hugely important. It's more to do with burden of proof and so on. The most recent case really is a MEXOM, and that case says the issue in that case was on what basis does the court decide whether or not to discharge the suspension. So how do they decide that? What principles apply? It was argued that the American cyanamide or campus oil principles, basically the same test for an injunction, should apply in these applications, and that's ultimately what the court decided. It was the High Court, Judge Costello. Now, there was probably scope for an appeal in that case, but the case settled ultimately. We adopted the English test, which is based on English legislation, slightly different to ours, so that may not be the last word in that, but at the moment the procedure is that an application is made to the High Court, the suspension kicks in automatically, the respondent can then seek to have that suspension discharged and enter the contract and go ahead with their work. And if they so apply, the burden of proof shifts. It's a very strange situation, and the person who actually challenged the decision in the first place will have to prove, in the same way as an injunction, why the contract shouldn't be allowed to go ahead. So it's a little bit complicated and convoluted, but as I say, these things move very quickly. A lot of it can be done on agreement, and there's a lot of cooperation between parties at all times. Okay, so I've just given you the cases there so that you have them. You have my name and details if you need them. I think we have a tiny bit more time. So are there any questions? We've absolutely flown through the procedure, obviously. The main takeaway, I think, is just to seek timely advice and to be aware that it is a judicial review application. Just in terms of the value of these claims, obviously a lot of them end up in the commercial court, and the mechanics of that is that you launch your proceedings in the High Court and get leave and get proceedings in being, and then after that you would make the application for entry, the motion for entry into the commercial court. If you as the challenger don't make that application, it's likely that the respondent will, depending obviously on the value of the claim. So that's how that works. Okay, thanks very much. I'll be around after.